Hi everyone, I'm Alysia Robben. I'm a staff attorney at the Kentucky Commission on Human Rights. I'm here to give you your law school lesson for the day. Pay attention, there'll be a quiz at the end. Some legalese and attorney gobbledygook is coming your way. All right, so fair housing laws as affirmative defenses to eviction. As you all know, at the Commission on Human Rights, we receive complaints from victims of discrimination, and we work to fix the problem. Typically, we are working to compensate them after the fact, after they've already been victims of discrimination. In housing cases, just for example, we've had a number of cases where a tenant has been evicted discriminatorily from the housing of their choice. And we later get a complaint, and we later determine that that eviction was discriminatory in violation of the Federal Fair Housing Act and the Kentucky Civil Rights Act. But a part of our mission is also to prevent discrimination. Discrimination of any type deals a serious blow to a person that cannot be fully erased by a monetary settlement or by a court order. In eviction cases in particular, a tenant who loses the housing of her choice may have to move into substandard housing, may be homeless, may have to move farther away from work or family, may have to transfer her children into a different school. And so, and I've represented complainants in all of these scenarios. So our legal unit recently, would someone say no? Sorry, legal unit recently posed a question, which is, oh, I have a question. Here we go. Sorry, I'm getting used to this. Question: can we prevent an unlawful eviction from happening in the first place? Or more specifically, what could a tenant or an attorney on the ground representing the tenant do during the eviction process or before the eviction process to prevent that discriminatory act from happening? Let me just give you a few examples of, can everyone hear me okay? I don't know if I'm, okay. A few examples of cases that we've seen where this has happened. These are real facts, but sometimes I've meshed a few cases together and the names have been changed. So Joanne, let's talk about Joanne. She requires a support animal for her disability. And this has been prescribed by her therapist. So she goes to her landlord, who unfortunately has a strict no pets policy, and she asks for a reasonable accommodation to that no pets policy so that she could have her support animal. Well, this particular landlord says no, in violation of the fair housing laws. Joanne goes on to acquire the animal anyway because she needs it for her disability. Well, the landlord proceeds to file a forcible detainer action. That's what an eviction action is called here in Kentucky. And Joanne is evicted. Because of the eviction, Joanne had been in subsidized housing. Because of the eviction, she is now unable to qualify for other subsidized housing units, and she's essentially homeless. Let's talk about Jana. Jana's expecting her first child. She's under a 1-year lease, but it's coming to an end, and she contacts her landlord and asks to renew her lease for another year. The landlord responds with, well, no children are allowed in this apartment building, so we're not going to renew your lease. And a month before the end of her lease term, she gets a notice to vacate. She doesn't vacate at the end of her lease term, and she's evicted. She's 8 months pregnant when she's evicted. She spends the last month of her pregnancy, the first 4 months of her maternity, bouncing around among family members' couches. Jennifer's a white female. She rents from a landlord who is also white. Before she signed her lease, she separated from her husband at the time. But during the lease term, they try to reconcile their marriage. So she asked her landlord, can he stay at the apartment for an extended period of time? The lease says guests can only stay for a week at a time, overnight, here and there, and the landlord says, sure, you're trying to reconcile your relationship, that's fine. Shortly thereafter, though, the landlord learns what he didn't know before, which is that her husband is black. The landlord calls her, verbally attacks her, states that her husband can no longer stay with her, and states he probably couldn't pass a background check. A few hours later, he serves her with a notice to vacate. A month later, he files a forcible detainer action claiming she has an unauthorized occupant in violation of the lease. After being evicted, Jennifer and her husband stay in a hotel for 2 months before they find an apartment with a comparable rent, but it's in another town and less convenient to her job. So in each of these cases, the landlord has acted in violation of the Fair Housing Act and the Kentucky Civil Rights Act. In each case, those laws should protect the tenant from being evicted in the first place. All right, so we went on to ask, can fair housing violations be raised as an affirmative defense? All right, here's your first legal lesson. What is an affirmative defense? It's a defense that will defeat the claim even if the allegations against the tenant are true. It's also known as the I did it but defense. You've seen this with an insanity defense, with a self-defense defense in a murder trial. It's, yes, I did it, but I have some complete defense that should get me off the hook. All right, so Joanne, yes, I violated the no pets policy, but you should have given me a reasonable accommodation for my disability. Jana, yes, my lease term had ended, but you should have renewed my lease, and the only reason you didn't was because I was having a child. Jennifer, yes, I had an unauthorized occupant, but the only reason he was unauthorized is because you discriminated against us based on his race. So in order to figure out whether this type of defense could be used at the moment of eviction and prevent the eviction from happening, we decided to gather some information. So we performed a survey of legal aid providers. Specifically, we obtained funding from HUD. Thank you, HUD. We partnered with Kentucky Legal Aid in Bowling Green, and they performed a survey of legal aid attorneys in Kentucky and nationwide. So these are attorneys who are providing free legal services during eviction proceedings for low-income tenants. So those are people, again, on the ground they're there at the moment of an eviction hearing. Can they talk to us about what's working and what's not working? We set out to answer 3 main questions. First of all, are attorneys raising fair housing laws as affirmative defenses? If so, how often? Are those defenses effective? Are they successful? All right, so let's talk about some of the data we got back on that survey. 123 attorneys, a few paralegals responded from across the country. 18 from Kentucky responded from across Kentucky. 80% of them have handled eviction cases in which the client, at least, asserted that discrimination was the real motivation for the eviction. 72% have raised discrimination as an affirmative defense. So about 3/4 of the attorneys have said, discrimination's happening here, let's bring it up in court. That ended up being a total of about 3,734 cases in the last 5 years nationwide among these attorneys, which was about 3% on average of each attorney's cases. So a small number, but still a significant percentage. So this is per year, about 3% on average of their cases. What type of discrimination were they seeing? Vast majority saw disability discrimination, and that was usually a failure to provide reasonable accommodations. That's the most common case, at least that was reported to us. 18% of those cases were race discrimination, 6% sex, 2% familial status, 1% national origin. All right, we asked some questions specifically about reasonable accommodations because from our own experience, we knew that that was a big issue. 91%, no. Okay, let me get rid of that. All right. So a full 91% of attorneys who responded have had cases where tenants needed reasonable accommodations, typically multiple cases. 79% have actually gone on to raise that as an affirmative defense. So let's find out if they were successful when they did that. Nationally, 54% of the attorneys responding stated that courts where they practice were willing to consider discrimination as a defense. So depending on if you're a glass is half full or glass is half empty person, you may see this as a high amount or low amount. I think it's pretty low. That means, I think 100% of judges should say, yes, you have a defense, let's hear it. But I think we'd all agree it's a high number compared to Kentucky, where only 11% of attorneys responding said that judges in the counties where they practice are willing to listen to these defenses and consider them. So the rest, 89% of Kentucky respondents, are saying that judges are not willing to listen to those defenses. And nationwide, many attorneys did, well, as you saw, at least half of attorneys did not find this successful. So let's look at some of the problems that they found. One category of problems was that it's difficult to prove discrimination. And of course that's a problem. The final person there said, we've never had enough evidence available to prove discrimination. The top answer there, I wouldn't want to let the judge decide fair housing issues because eviction judges have full dockets and don't have the time for a nuanced fair housing case. So there is a concern that a complex discrimination defense may not be fully heard by a judge who's trying to get through their eviction cases like that. Another problem is we don't have the resources or time. One attorney said, in my 25 years, we've not been equipped to do the kind or amount of discovery that we feel would be needed to attempt to be successful in such an assertion. So again, essentially, these cases can be hard to prove. I need time to prepare the case. There's not time. Another type of problem attorneys have encountered is judges that are not receptive. That third quote there, courts in our area are not receptive to the defense. So obviously that's shared by many Kentucky attorneys. In strong cases, I was concerned about the res judicata impact of litigating the issue in a limited jurisdiction eviction case with an always hostile judge. All right, what does that person mean? They mean, I'm going in front of a judge who typically rules in favor of the landlord over and over and over again. Do I want them to hear my discrimination defense, rule against my tenant as they typically do, and potentially put my tenant in a position where they can't file a complaint with the state fair housing agency, for example, because the issue's already been decided. And that's a concern that our legal unit shares as well. The last one, in rural areas, discrimination is taken as a fact of life rather than a viable affirmative defense. Wow. And then in many courts from across the country, we've heard that affirmative defenses are procedurally unavailable. So the local state laws or procedural rules just simply don't allow them to bring up these defenses. I want to read just the last one for you. In Arizona, the rules and law here do not allow discrimination as a defense to an eviction action. The judges don't even entertain the defense, and tenants usually have 48 to 72 hours to prepare their cases. So 2 to 3 days to prepare their case. It's simply not possible to use discrimination as an affirmative defense for eviction in Arizona. The Arizona eviction law is brutal for tenants. And we're finding that that pretty much sums up what the law is like here in Kentucky for tenants. And we'll get to that a little bit more in just a second. Now, what about the attorneys that are having success nationwide? What can we learn from them? What strategies are they using? So many of them talked about referring their clients simply to other organizations who specialize in civil rights and human rights, who could get involved in one way or another to help them. That doesn't always answer the question about helping someone immediately at the point of an eviction proceeding. But we did hear from attorneys who are able to get folks involved to negotiate some sort of resolution. Some attorneys are filing affirmative claims, so they're actually going to state or federal court or perhaps HUD and filing a complaint on behalf of their client. Saying not just defensively, let's defend ourselves from eviction, but let's actually offensively take action and say that this landlord is discriminating against me. Some attorneys in their jurisdiction can file counterclaims. That's not true here, as far as we can find. And all of these steps the attorneys are reporting create leverage to be able to settle the complaint altogether and prevent the eviction. We're also seeing attorneys who are filing affirmative defenses in their states. So unlike the other ones we just heard from, some attorneys can do this. Their states do allow it. The first person says, yeah, case law establishes that reasonable accommodation is a good defense. The second attorney, in contrast, says in Wisconsin there's not clear law on whether a reasonable accommodation argument can be raised, but we do it all the time because we think it should be. And the final person said it's common to assert fair housing affirmative defenses, and it's effective. So what about Kentucky? Kentucky eviction procedures. As I mentioned earlier, 11%, which was only 2 of the 18 attorneys that were responding, stated that in their county, the judges are willing to consider discrimination defenses in eviction cases. One attorney we spoke with referred to eviction proceedings in Kentucky as the Wild West. You get 3 days notice before the hearing. On the day of the hearing, you have a bench trial the moment you walk up to that table when your case is called. And you know, we've heard from many attorneys that typically the judges are crediting the landlord testimony. So what the landlord says, the judge believes it. And what the tenant says, the judge doesn't believe it. And additionally refuses to hear tenant defenses. So earlier we were talking about the I did it, but defense. So the judges are hearing I did it and stopping there and not listening to the but. As long as you say I did it, you're done, you're evicted. In Kentucky, procedurally speaking, you can raise an affirmative defense, but as we just talked about, judges aren't really going to hear it. You can request a jury trial, but in some counties, it'll be scheduled the exact same day that you ask for it, sometimes maybe a week later. For any attorneys in the room, that's a struggle. Getting ready for a jury trial in about 5 minutes. There is no right to discovery in an eviction trial. There's no time for informal discovery, meaning within that 3 days notice, there's really little time to talk to witnesses, to try to look for records, to prepare yourself to present that defense. And many times the legal aid attorneys actually have even less than 3 days. You know, they'll talk about how their clients call them the day before and say, hey, I have an eviction hearing tomorrow. So we're often looking at about 24 hours preparation. So what did Kentucky attorneys do then? You know, they're not giving up. They are still fighting for their clients. Here are some strategies used by Kentucky legal aid attorneys. So lots and lots of people said that they get Lexington Fair Housing Council involved. They get Art Crosby on the phone, sending a letter, and he's, you know, I think commonly in reasonable accommodation cases that he's able to get involved and demonstrate to the landlord, the tenant has the right to this accommodation, you need to give it to them, can we get some more time, or can you just call off the eviction altogether? Some attorneys send their client to us, to the commission. We've had a couple times where an attorney has called us and said, what can you do here? And so we get on the phone and kind of like Art, we call the attorney for the landlord and we talk to them about how we have a complaint, we need to investigate it, we need to figure out whether discrimination is happening. It'd be a good idea and in your best interest to hold off on evicting this tenant. Let's just keep things the way they are till we figure out what's going on in this case. And that's been effective here and there. Okay, I'll be done in a couple. Some attorneys have found it helpful to actually file a written answer where they do claim that there's been a fair housing violation. So even if the judge is not hearing it, even if the judge won't really take it into consideration, a couple times attorneys have found it educates the landlord or educates the landlord's attorney, getting them fearful enough of the repercussions later to say, wait, can we try to work this out? Again, that tends to be most successful in reasonable accommodation cases. I think those are a little bit more clear and a little bit more sympathetic than an accusation that you're acting in a racist way, you know, that you're acting in some discriminatory basis. And attorneys have also asked for jury trials in some instances. It might give you a little bit more time, and it might also give you an opportunity to put those facts in front of a jury. So even if the judge is not instructing the jury about fair housing laws and how to decide that, I've had one attorney say that just presenting the information and showing that the landlord was acting based on race, in his opinion, caused the jury to rule for his client, because the jury said, whoa, you're acting based on race, this isn't fair, and found in favor of the tenant. So those are some of the strategies that we've been seeing, and we're going to continue to use the data that we've got from this survey to inform ourselves. We're going to continue to do interviews with other attorneys across the state, continue to do legal research, and ultimately we hope to present to the public our findings as well as some recommendations that go beyond what attorneys are already attempting to do. Some of those are coming from what we've heard from attorneys across the country. So these might look familiar to you. Earlier we talked about some attorneys filing affirmative suits. So going into circuit court, our eviction hearings are in district court, going above them basically to circuit court and saying, filing an affirmative complaint, saying my client's been discriminated against, and then filing a motion to tell that judge to order the landlord to stop the eviction. So put it on hold until we can figure out whether a fair housing law is being violated. And then another suggestion we have is to file more written answers with affirmative defenses. So bring those defenses up. At least one judge has told an attorney that, you know, I might not have jurisdiction in district court at this low level to hear discrimination claims. That might be better in circuit court. I think attorneys should try getting eviction cases sent up to circuit court where things can be a slower pace, where discovery can happen, where tenants have the opportunity to fully present their defense. Again, ultimately, what we're trying to figure out is how can a tenant get full due process, the opportunity to stay in the housing of their choice instead of suffering from discrimination that we're trying to make up for after the fact. All right, thank you. Any questions about the work that we're up to?
One of the things that we do, John Fisher, Human Rights Commission.
Hi, John.
One of the things that we do in outreach and education is we work with like a lot of local city councils and things that educate them about the law. I wonder if maybe we should, if we haven't already, like try to work with the judges to make them more sensitive about the needs of the residents. You know, like with the, I'm sure that there are district judges associations and circuit judges associations, and maybe when they have their conventions, maybe we can get like a presentation to them to make them more aware.
That would be great if we had that opportunity. I think at least for a first step, we're hoping to publish a report and perhaps an article in the Kentucky Bar Association's magazine, which is read by judges, and so that might be an opportunity to start educating them, or at least opening their eyes a little bit to these defenses. Yeah.
In your research and talking to folks in Kentucky, do you find any differences in attorneys who are practicing in areas where the workers' language and that was in fact versus jurisdictions where it wasn't?
Am I supposed to repeat the questions? Okay. The question was, are attorneys finding differences in jurisdictions where the Uniform Residential Landlord-Tenant Act is in place versus where it's not? And that is a question we've been asking them. So far, I'm not getting much of a difference from them. And you know, I think in my head, when I was approaching that question, I thought that the judges were only hearing Uralta cases or only not hearing Uralta, hearing non-Uralta cases. And then I discovered a judge might hear Uralta cases from Georgetown, but otherwise the Scott County cases the same judge is hearing are not covered by Uralta, if that made sense to everyone. So there's mixed jurisdictions, in other words. And so those judges are having to switch their brain, but I don't think they're acting any differently. And I'm not sure yet whether Uralta itself is giving any additional procedural or legal protections, but yeah. I can name one instance where I think community organizations should get more involved, which is tenants who have a mental illness or mental disability. And we're seeing cases where the tenant is perhaps violating the lease in some way because of their disability. Perhaps they're damaging the property or they're making too much noise, something like that. They're not keeping up the cleanliness of the apartment. Now, if a community organization can get involved and help that tenant not just stop that behavior, but perhaps ask for a reasonable accommodation from the landlord, that really helps set things in place before it gets to the point of eviction. Because once that eviction is in place, there's just such a fast turnover. It's such a short amount of time that the tenant has to act within that often it just is too late for a community organization at that point to really help prevent the eviction. But in mental health situations, I think there could be a lot more advocacy going on there. All right, so the question was essentially, if a judge tends to be ruling against tenants, are they acting in a discriminatory way? And does the recent Supreme Court decision on upholding disparate impact claims, does that play any role? I believe that our particular Kentucky Civil Rights Act does not apply to the judiciary. There's also problems raised with tenants not being a protected class. So you're looking at not one particular protected class. But hopefully when Supreme Court decisions like that come out and we just continue to raise awareness generally of the protections under the Fair Housing Act, maybe that can end up having an impact on judges.